Good afternoon, everybody. It is terrific to be here with you again. It's October 17th. I'm in New York City at our offices in Midtown, and it's beautiful out there. Last evening, I saw a rainbow arc right outside of my office window. I'm hoping that's a sign of good things around the corner. I'm hoping that we find all of you in good stead. And we have a full program this afternoon, which we think will address a variety of issues that you'd like to learn more about that are topical and that'll leave you with some food for thought as you're ostensibly munching away at your desk while watching this here. So I'll start as I typically do. Then I'll turn over to Amber Lawyer, who's with us. Amber is going to discuss the Delaware decision, as it were, to join the consumer protection bandwagon. Amber is with us from Syracuse, I should note, and is the deputy chair of our data privacy and cybersecurity practice. A friend of the show has been on a number of times. Speaking of friends of the show, we have Sandra Casey next. Sandra's with us from Albany. She'll be talking about a higher ed matter, the gainful employment rule, which is getting a lot of buzz, and we're going to talk more about that after Sandra follows Amber. And then Carl Dubel, also with us from upstate, and specific from Rochester, is going to be looking at a Court of Appeals case that is timely for all of you who are baseball fans. As a Mets fan, I am feeling a little bit bereft at this moment as I watch other teams go on. This was not the Mets here, of course. But we'll be talking a bit of baseball, and I look forward to that. Kamisha Perkins will be next, supervised by Mallory Campbell. And it's important to note that Kamisha is not yet admitted to the bar, but has been with us at Bond for several summers, and we look forward to Kamisha's work on an ongoing basis as soon as that changes. And Kamisha is a member of the bar, and supervising her will be Mallory Campbell, an attorney also of our New York City office, who's familiar to all of you. And Kamisha is going to be addressing amendments to New York City's Earned Sick Time and SAFE Act. And then I'll be here to wrap things up and close out in roughly 45 minutes. So why don't we get started, and I'll introduce our next and first presenter, as it were, more formally. So Amber has been on the show a gazillion times, if that is a term of art I can employ. And it is Cybersecurity Month. We are really looking forward to reminding all of you why it's important. There's a context here. And as the deputy chair, Amber's going to talk about what's happening in Delaware, but it's relevant for all of you because you all should be thinking about your cybersecurity posture, being otherwise focused on it. And this month is an opportunity where not only will we be bringing programming on today, but as well later this month, we expect to hear from Jessica Copeland, who's the chair of the practice out of Buffalo. So stay tuned for that. In the meanwhile, Amber, so glad you can be with us, and I'm looking forward to learning. Thanks. The floor is yours.
Thanks so much for having me, Gabe. Great. Next slide, please. Okay, so as Gabe mentioned, I wanted to just briefly talk about Cybersecurity Awareness Month. I know we've already presented briefly on this topic and a couple of the other webinars, but I wanted to highlight for everyone that it's the 20th annual Cybersecurity Awareness Month, which is an initiative in the United States and globally to really raise cybersecurity awareness throughout the country and the world. And as I'm sure many of you are aware, cybersecurity has become an issue for entities throughout all industries, right? So we see it from manufacturing to higher ed to the business sector and the nonprofit sector. Entities are struggling with their security posture, their safeguards, and making sure that they can keep personal information protected. This year's theme is Secure Our World, with a goal to enhance cybersecurity around the world and to ensure that when you're transferring data between entities and your business partners and your clients and your employees, you're maintaining secure information. So what Bond is doing is presenting a series of podcasts, webinars, speaking engagements, and then articles in relation to Cybersecurity Awareness Month. So we've already sent out a few articles, including a great one that was released yesterday on corporate executive personal liability in the event of cybersecurity failures. So if you're a corporate executive and you fail to put in place appropriate safeguards to protect information, the FTC is now holding corporate executives personally liable in those instances. So check out these articles for more information. And then we actually had quite a few members of our cybersecurity team up for this month's Legally Bond podcast. And we did a special episode, which came out last Tuesday. And we talked about what you would see in Cybersecurity Awareness Month, some of the key topics for our team in relation to cybersecurity, and some of the steps that we think entities should be taking in order to protect their information. Next slide, please. Okay, so as part of Cybersecurity Awareness Month, I wanted to give a little bit of an update on where we stand in US data privacy law. And of course, that sounds a little bit odd because one is cybersecurity and one is data privacy. But it's very important to note that state data privacy statutes often mandate cybersecurity measures. And what I mean by that is a state data privacy law, a consumer protection data privacy law, will mandate that an entity has certain physical, administrative, and technical cybersecurity safeguards in place to protect the information that's subject to the statute. I wanted to present this map, which is from the International Association of Privacy Professionals, to really give everyone an overview of where we stand in the United States. So in the US, we have many states that are proposing consumer state privacy laws. We also have many states that have enacted privacy laws now, and some that are just in the early stages. What's important to note is that 4 years ago, the only state that was at play was California. So California would be the only green state on this map, and here we are today. Really important for you all to note that that is the pace that we're moving at, quickly expanding privacy landscape. And you may be entities that are only located in New York, but it's important to note that these laws are extraterritorial in scope, which means they don't apply only to entities located in that state, but instead apply to entities that process the information of individuals located in that state. So you could be an entity in New York that processes the information of residents of Texas, and you could still be bound by the law. Okay, next slide, please. So I wanted to, after looking at that chart, I wanted to talk quickly about the actual enacted laws and where we are and the effective dates. So as I mentioned, California was the first state to pass a consumer privacy law. It became effective in January 2020, and then it was amended with a subsequent law, and that law came into effect of January 1 of this year. We also have Colorado, Connecticut, Delaware, Indiana, Iowa, Montana, Oregon, Tennessee, Texas, Utah, and Virginia. So we have 12 states right now that have enacted consumer privacy laws. And currently effective, we have Virginia, Colorado, California, and Utah will be effective at the end of this year. Why does this matter to you? And why am I telling you about laws that are enacted but not yet effective? Well, it does take a while to become compliant with consumer data privacy laws. So entities need to be concerned about their compliance posture when complying or when these laws come into play. So it takes a while. It can take up to a year to build out a consumer response process and to build out a compliance mechanism. I see someone in the Q&A has asked about New York Shield law. That is a cybersecurity law in New York State. So New York State does not have a consumer data protection law yet. They have proposed legislation in the last 2 legislative sessions, which has not passed. But what New York State does have is exactly what you've noted, which is New York Shield Act, New York Shield Act is a cybersecurity law that both has a cybersecurity mandate, like what I was talking about, and it has a breach response portion of the law. So it articulates what you need to do if your entity has a data breach, but it also articulates what security measures you need to have in place. So similar to some of these privacy laws, and because New York doesn't have a general consumer privacy law yet, that's where we stand in New York. Okay, next slide, please. So today I want to talk about the Delaware Personal Data Privacy Act. And the reason why is, first and foremost, it just passed in September. So it is the newest consumer data privacy law we have. But secondly, the Delaware Privacy Act has a much lower threshold than any other consumer data privacy law that we've seen so far. And what I mean by that is most US state consumer privacy laws have a minimum threshold of data points that you're collecting from residents of a state in order to be subject to the law. And so Delaware's applicability applies to entities that control or process the data of 35,000 Delaware consumers annually, excluding data for payment transactions, or control or process 10,000 consumers' personal data and sell that data. So derive some kind of gross revenue from that data. This is a very low threshold. By way of example, California's threshold is 100,000 consumers, and so is Colorado. And the other states are somewhere between 50,000 and 100. And so we have a much lower threshold in Delaware. Of course, it's a smaller state, but it's important to note because many entities are probably going to fall into this scope. If you have a business that is in the e-commerce sector or that does any kind of data collection online, and you're collecting data of Delaware residents, you probably are going to fall within the scope of the Delaware law. Very important distinction that has come out of Delaware that we have not seen in other consumer data privacy laws is that it applies to nonprofit organizations, including institutions of higher education. So most other consumer data privacy laws, in fact, all of them with the exception of Colorado, include a nonprofit organization exemption. In Delaware, we have a limited nonprofit organization exemption, but it's a very specific scenario. And so generally nonprofits will need to apply here. What does consumer mean? It means a resident of Delaware. So if you're an entity that collects information from residents in Delaware, you may be pulled into this law. One other important note here is that the Delaware privacy law excludes employees. So if you have employees located in Delaware and you're collecting their personal information, that will not count towards this threshold requirement. And you do not have to comply with the law in relation to employment information. Okay, so then next slide, please. And while we're changing to the next slide, I do see there's a comment about BIPA. Yes, so the laws I'm citing right now are just general consumer data privacy laws. There are also sector-specific data privacy laws or data-specific privacy laws. So Illinois has the Biometric Information Privacy Act, BIPA, which regulates the collection of biometric information. There are several other states, I believe Washington and Texas, that also have biometric information data privacy laws. We also have health privacy laws. So Washington just came out with the My Health Data Act, which is a health data specific privacy law. So we do have sector specific, data specific laws, and then we have the laws that I'm talking about today, which apply to consumer information generally. So it can apply to both biometric information or personal information generally of consumers. So what does the law afford for consumers? It affords consumers rights, a set list of enumerated rights in which entities must comply with those rights when a consumer makes a request. Those rights include the right to access the consumer's personal data, the right to correct, the right to delete, the right to obtain a copy of personal data, the right to obtain a list of third parties to whom data has been sent, and the right to opt out of targeted advertising, personal data sales, and profiling. So you all have seen this probably in the California realm when you're on Amazon or any other big retailer that is certainly subject to all of these laws. They will have already built out these mechanisms to submit these consumer rights requests. And so you probably have seen them before. It's important to note, though, that if you're an entity that is subject to any of these state laws, you have to build out this compliance mechanism. And you have to allow consumers to submit rights requests. And those rights may vary depending on what state law you're subject to. A couple of other quick notes. I know I'm running low on time here. The expanse of personal data and sensitive data, so the definitions of both personal data and sensitive data under these laws, is much more expansive than other privacy laws that you're used to. So personal data pursuant to these general consumer privacy laws includes things like an IP address, someone's mailing address, logging information, click information on a website. And so the scope of the law is extremely expansive. And it also qualifies that if you're collecting certain sensitive data, like biometric information, like data relating to gender or ethnicity or social security number, of course, financial information, you have to have additional protections for that information. Next slide, please. Okay, so what does this mean for your business? It is early, of course. The Delaware law doesn't become effective until January 1 of 2025. But it's really important to note that now is the time to determine if you're subject to the law. If you are subject to the law, you need to do due diligence and potentially a data audit to determine how much Delaware resident data you're collecting. You then need to start building out these compliance policies and processes that I'm talking about. So you need to create updated policies, create that consumer request mechanism, do a risk assessment, a data audit. You oftentimes have to modify your contracts with both your vendors and your clients if you're collecting client information. And you have to implement those cybersecurity measures I was talking about. So just like New York Shield Act, you have to maintain adequate cybersecurity measures to protect this information that is now subject to the law. So you have several steps to go to, and it can take an entity quite a while to build out this process, especially if you're not compliant currently with any other consumer state privacy law. Okay, next slide, please. I think that's it for me. If there are any other questions, I'm happy to answer them in the Q&A or to answer them via email. Thanks so much, Gabe.
Thank you, Amber. That was really informative, and I'm looking forward to hearing from Jessica in 2 weeks' time. This was a great way to stay focused on cybersecurity over the course of this month. And Amber, you're always welcome back on the program. Let me shift now, to our next speaker, who is Sandra Casey, who's senior counsel up in our Albany office. Sandra's going to be focusing on higher education, which is her area of practice, and in particular, the gainful employment rule. So Sandra, we're delighted that you are back on the program. We look forward to learning with you. And it looks like there's some issue with your lighting. However, we see you just fine. So please go right ahead, and we look forward to your presentation.
Thanks, Gabe. You know, I was here all day and the lights stayed on, and the minute my camera turned on, the lights went off, so I apologize. Anyway, I'm going to talk to you today about the Department of Education's final gainful employment rules and a new financial value transparency framework that will affect all institutions of higher education that participate in Title IV student assistance programs under the Higher Education Act. So the gainful employment rules established by the Department of Education and recently amended relate to gainful employment ongoing concerns about educational programs designed to prepare students for gainful employment in a recognized occupation. But according to the department, they fall short of their mark. They leave students with unaffordable student loan debt in relation to their earnings, according to the department, or with no gain in earnings compared to others with no more than a high school education. Next slide, please. So what are gainful employment programs? Well, they're proprietary school programs that provide undergraduate or graduate training that prepare students for gainful employment in a recognized occupation, or programs at other nonprofit or public institutions that provide at least a one academic year training program that leads to a certificate or other non-degree recognized credential. So community colleges typically fall under this definition in programs that they provide. The department estimates there are 32,000 such programs that enroll about 2.9 million students who receive Title IV each year. The gainful employment programs represent about 20% of the more than 155,000 Title IV eligible programs and about 15% of about 19.3 million Title IV recipients. Next slide, please. Under the GE program accountability framework under the regulations, the department assesses whether career programs meet the statutory requirements of preparing students for gainful employment using two separate and independent metrics: a debt to earnings rate that compares the median annual payments on loan debt borrowed for the program to the median earnings of its federally aided graduates. For a program to pass this rate, its graduates' debt payments must be no more than 8% of annual earnings or 20% of discretionary earnings. Then there's a new earnings premium, another metric, a new earnings premium test that measures whether the typical graduate from a program who received federal aid is earning at least as much as a typical high school graduate in the labor force in their state between the ages of 25 and 34. This is equal to roughly $25,000 nationally, but it varies by state. Next slide, please. So debt to earnings ratio. What's the department's philosophy about this? The debt to earnings ratio measures loan affordability, the share of borrowers' annual earnings that need to be devoted to making student loan payments. This is what they're concerned about. The department estimates that borrowers in programs with unaffordable debt are 25% more likely to default on their loans compared to programs where borrowers are enjoying passable DE rates. The DE rates also help identify programs where taxpayers are likely to bear the cost of federal loans. This is what the department's concerned about. You know, what's the burden on taxpayers? Since borrowers can repay their loans as a fraction of their discretionary earnings for a fixed number of years under popular income-driven repayment plans, when debt is high relative to earnings, borrowers will be less likely to repay their full balances, according to the department. Next slide, please. So the earnings premium, the department's philosophy on the earnings premium test is that it captures the extent to which post-secondary programs enhance a student's earnings potential relative to not pursuing a college credential at all. The vast majority of students cite improved earnings or job prospects as among the most important reasons they choose whether and where to attend college, and the earnings premium measures whether programs are meeting that basic expectation. Among individuals with at least some college experience, rates of material hardship, experience food insecurity, or being behind on bills are more than double for individuals with annual income below that of the median high school graduate in their state compared to those with income above that threshold. Next slide, please. Okay, so what happens to GE programs that fail either metric? So GE programs that fail either metric in a single year will be required to provide warnings to current and prospective students that the programs could be at risk of ineligibility for Title IV. That's huge in subsequent years. Programs that fail the same metric in 2 of 3 consecutive years will not be eligible to participate in federal student aid. And institutions cannot regain eligibility for 3 years for ineligible programs or substantially similar ones. So again, that's a huge detrimental consequence of failing either metric. Next slide, please. The financial regulation also establishes a new framework, which according to the department will enhance transparency by providing information about financial costs and benefits to students at nearly all academic programs at post-secondary institutions that are eligible to participate in Title IV. So pretty much all schools around the country will be affected by this new VFT framework. Next slide, please. Under the VFT, the department will determine the debt to earnings ratio and the earnings premium metrics based upon information the institution must report to the department starting in July 2024. Beginning in 2026, the department will host a new program information website that will publish these metrics for all academic programs at institutions, along with other information the institution has reported on, including standardized information about program costs, tuition and fees, books, supplies, etc., non-federal grant aid, loan burden, both private and federal loans, earnings of completers, and applicable occupational and licensing requirements. This website will give students and families a personalized estimate of what they'll pay out of pocket to earn credentials in a specific post-secondary program. Institutions must display on its website a link to the department's website. Next slide, please. The VFT also mandates affirmative steps be taken for prospective students at institutions with failing debt to earnings ratios. Specifically, these institutions must obtain prospective students' acknowledgement that they have seen the financial information on the website, including a plain language description of the fact that the program leaves its graduates with high debt burdens before the student can even enroll in the program. These requirements will apply to prospective students at certificate and graduate degree programs only. The department chose to exclude undergraduate degree programs from this provision in the final rule. Next slide, please. So start gathering information now. The information that must be provided in July 2024 is set forth in 34 CFR 668.408, which I will link to in my presentation that'll be posted on our website. And includes not only program data such as program accreditation and licensing requirements, to name just a few, but detailed student level data as well. For example, each student's cost of attendance, annual allowance for books, equipment, supplies, food, and housing, etc. The information that must be provided has a look back of 6 years or 2 years, depending on certain conditions. The department will issue further detailed guidance on uploading the information, hopefully very soon, because it's less than a year before the reporting must start in July of 2024. In conclusion, these final regulations affect all institutions and will require much work by many departments on campuses. So all hands on deck, as they say. Thank you, Gabe, for allowing me to present on this important topic.
Oh, well, thank you for coming back on and for giving our clients and friends in higher education a heads up about all this important activity. And please check in with the bond attorney that you work with most closely if you have questions and follow up. And again, Sandra, thank you. Let's turn to our next speaker, who's Carl Dubel, who is with us from the Rochester office. And Carl is a litigator with multiple years of experience, and among other stops he had in advance of joining Bond was one here in New York City, working as an assistant district attorney in the New York County District Attorney's Office. I was chatting with Carl in advance of the presentation, and Carl lived within walking distance for a while of our New York City office. But he's back in Rochester and is ready to tell us about a really interesting bit of litigation that involves baseball, well-timed, given that we are in the playoffs. And I look forward to learning more about it from you, Carl, and welcome to the program as well. Welcome to Bond.
Thank you very much, Gabe. Good afternoon, everyone. My name is Carl Dubel, and I am associate here in Bond's Rochester office. As Gabe mentioned, I'm in the litigation department, but I'm also a member of the school law practice group. Today, I'm here to discuss two cases that were recently decided by the New York State Court of Appeals, which is the highest court in New York State. These cases involve the tort law doctrine of assumption of the risk. While this doctrine has ancient origins in Roman and English common law, as the Court of Appeals recently found, it still has very important applications in the area of collegiate and youth sports. This review should be especially relevant to any of you who are involved in any way with organizing youth sport programs, running sports programs, or hosting sporting events, whether it be varsity sports or more recreational kind of youth sports programs. It's also timely given that we are in the thick of playoff baseball, as one of these cases involves a varsity baseball player. Essentially, the assumption of the risk doctrine says that an injured plaintiff will not be able to recover from a negligent defendant if the plaintiff voluntarily accepted the risk of being injured from the defendant's actions. This is relevant in youth sports because where an athlete is injured in the normal course of participation in their sport, the defendants who would potentially be liable for that athlete's injuries, such as a coach, a school district, or a municipality, will not be liable because the athlete will be deemed to have assumed the risk of their injury as a result of their voluntary participation in the sport. However, the Court of Appeals recently decided 2 cases involving high school varsity athletes and said that there is a limit to this assumption of the risk doctrine. The Court of Appeals' recent decisions highlight the fact that just because a student athlete decides to voluntarily participate in a sport does not mean that they have assumed the risk of every possible injury that they can suffer. The court made clear that schools, universities, and municipalities can still be liable for the injuries of their student athletes if the entity or their employees unreasonably enhance the risk or conceal the risk of a potential injury. So in the first case I'm here to discuss, I will refer to it as Grady. The injured student athlete was a varsity baseball player. The plaintiff was injured during an extremely complicated fielding drill where 2 baseballs were hit into play at the same time by 2 different coaches. The baseballs were then simultaneously thrown in the direction of 2 players who were standing near each other in the same area of the field by first base. The plaintiff, who was supposed to catch one of the baseballs, was hit by an errant throw that was intended to go to the other player that was standing next to him. As the Court of Appeals noted, while in most normal circumstances, a baseball player assumes the risk of being injured by an errant throw during baseball practice, that might not be the case in this situation because of how complicated the coaching staff made this particular fielding drill. The court said that a jury had to decide whether the coaching staff, and by extension the school district, unreasonably enhanced the risk of injury beyond what one could normally expect when signing up to play varsity baseball because of the complex nature of this fielding drill. Now, in the second case the court decided, which I will refer to as Secchi, the court reiterated that the assumption of the risk doctrine is still going to have applicability in most sports situations. In this case, the plaintiff, a varsity-based basketball player, was injured during basketball practice. Secchi was participating in a rebounding drill where he competed against one of his teammates for a rebound. But for this drill, the coach told the players that the normal out-of-bounds lines on the basketball court would not apply. During the drill, the plaintiff collided with his teammate, and he injured his shoulder when he ran into the retracted gymnasium bleachers that were near the basketball. The Court of Appeals held that the risk of this injury from colliding with an open and obvious hazard near the basketball court was not unreasonable or concealed, and that this risk was inherently obvious to all those who voluntarily participate in the sport of basketball. Therefore, unlike in Grady, the plaintiff here was completely denied recovery for his injury. Just in a short conclusion, I will warn that it's important for any of you who find yourselves in a similar position as the defendants in either Grady or Secchi to be aware of the facts of these cases. These decisions mean that lawsuits that arise from on-the-field sports injuries will likely create more complex and lengthy litigation than they have in past circumstances. If any of you have specific questions or concerns or wish to seek legal advice on how to best monitor your sports programs or anything related to them, please contact either myself, another bond attorney, or if you're in regular contact with a normal attorney, I'm sure they would be willing to talk to you as well. Thank you for your time this afternoon.
Carl, thank you. And I really appreciate the efforts you've put forth to walk through these nuances, because these instances that you describe are distinct. One involving a truly complex baseball drill, which sounded, almost impossible to execute safely. And the comparative notion of bleachers that were exposed as a touch point to think about as distinct. All of that, I think, is to your comment of a moment ago that talking with attorneys, is important when you have potential risks, and we're here at Bond to help you with that. So, Carl, please come on back to the program whenever you have new information to share. And again, welcome to Bond and welcome to the program. Let me turn to our final speakers now for the afternoon. We have with us two. First is Mallory Campbell, who is an associate and who has been on the program many times over, focuses on a variety of activities out of our New York office in the vein of complex labor and employment litigation. And during the early days of the pandemic, you may remember Mallory as a regular contributor to this program in particular. She has been supporting Kamisha Parkins as Kamisha, who's an associate trainee, gets up to speed. As I mentioned in the opening moments, Kamisha has been with Bond previously for a couple summers and is known well to all of us around the New York City office. Mallory, let me give you an opportunity to share a bit more about this presentation and about Kamisha. Mallory, please.
Yeah, hi everyone. Thanks so much for joining. As Gabe mentioned, my name is Mallory Campbell, and I'm an associate in the New York City office. I have the pleasure of introducing Kamisha today. So Kamisha is an associate trainee in our New York City office. She spent 2 summers with the Bond firm, and she is a recent law school graduate, but not yet admitted to the bar. So I'm here supervising and able to answer any questions that might come up. So I'm going to hand it off to Kamisha, who's going to discuss the New York City safe and sick leave law.
Yes, thank you so much, Gabe, and thank you, Mallory, for the introduction. Hello to everyone.
Kamisha, this is Gabe. Before you go further, I'm sorry, we're having a little trouble hearing you. So if you could please adjust your microphone, that would be great. Thank you all for your patience.
Can you hear me now?
We can hear you, and just please make sure to enunciate. That would be terrific.
Okay, my apologies for technical difficulties. So yes, as I was saying, I was just thanking Gabe and Mallory for the introduction. So good afternoon, everyone. Today I will be discussing amendments that were made to the New York City's Safe and Sick Time Act. So on September 15th, the New York City Department of Consumer and Worker Protection did adopt amendments to the ESSPA, or we refer to the Safe and Sick Time moving forward, to clarify the law as it relates to safe sick time. And so I will just be discussing some of the key changes that New York City employers should be aware of. So first, the amendments clarify that a covered employee under the ESSPA is an employee who performs work, including remote work, while physically located in New York City, and this employee is considered employed for hire within the city of New York. This is regardless of where the employer is located. An employee who works primarily in another state is also covered by the ESSPA, as long as they regularly perform or are expected to regularly perform work in New York City during a calendar year. And I do want to note that only working hours performed in New York City will count for leave accrual purposes, which I will discuss a little later. Employees who work remotely, on the other hand, and outside of New York City are not covered under the ESSPA, even if the employer is an NYC employer. Now, as has always been the case, private employers with 100 or more employees must provide up to 56 hours of paid safe and sick time annually, and employees with 99 or fewer employees need only provide up to 40 hours of safe time annually. The amended rules clarify that an employer determines their number of employees by counting the highest total number of employees employed at any point during the calendar year today. And so this includes full-time employees, part-time employees, those employees who are employed by one or more employers, employees on leave of absence, suspensions, and other temporary absences. This is so long as the employer has a reasonable expectation that the employee who is on a leave of absence or suspension or other temporary absence will in fact return to work in 2020. The amendments also clarify that a covered employee's regular rate of pay for safe and sick leave is very simply the employee's regular rate of pay at the time that the safe or sick time is taken. The amendments also clarify when it is permissible to request documentation from employees for safe and sick leave. And so a New York City employer is not permitted to require documentation from an employee if the use of sick time lasts 3 or fewer consecutive work days. However, in instances where an employee's leave lasts a longer period of time, an employer is permitted to require documentation. And when requiring that documentation, an employee is allowed a minimum of 7 days from the date he or she returns to work to submit the request for documents under the ESSTA. And the ESSTA amendments provide further details regarding the contents of the documentation from employees and how it should be submitted. It's also outlined in the amendment rules, but for purposes of time, I won't go that much into detail. But I do definitely want to highlight an important update that the amendments require of employees, of New York City employers and their ESSTA policy. So if an employer requires employees to submit documentation in support of their use of safe and sick leave, then this must be specified in the written policy, as well as the documentation that the employer will accept and instructions on how employees can submit the documentation. And just a caveat, if the employer, happens to withhold payment until such documentation is provided, then the employer must also include this in their policy in terms of how the employee can submit requests for any reimbursement. The amendments continue and state requirements for seeking advance notice from employees for use of sick leave. And essentially, it's a foreseeability test. So where an employee's leave is foreseeable, an employer can require that the employee provide reasonable notice as long as the requirement to provide such notice and the method of providing such notice are set forth in the employer's written ESSTA policy. An employer that requires notice of an employee's unforeseeable leave must provide a written policy that contains reasonable procedures for the employee to provide notice as soon as possible. And another update that should be made to an employer's ESSTA work policy as well, which is very important, is that an employer must include a more specific statement regarding confidentiality. So what this means is that the employer must state very plainly that they will not inquire about an employee's medical condition or personal situation that led to an employee's use of safe or sick time, and that any information that the employer receives about the employee's use of safe or sick time will be kept confidential and not disclosed to anyone without the employee's written permission or as required by law. And very important for employers to know that failure to comply with these requirements listed in the ESSTA can result in a broad range of penalties that will be imposed on a per employee basis. So to conclude, I want to share that these amendments did take effect on October 15th. So Bond does advise New York City clients to update their employee handbook as soon as possible to reflect these new changes if you haven't done so already. Thank you.
Kamisha and Mallory, thank you both. And Kamisha, just wanting to underscore the point you made that looking at your handbooks is critical right now. And it doesn't go, I should say, only for our New York City clients, even though the language that Kamisha summarized is specifically applicable to New York City employers. Analogous issues arise across the state, let alone elsewhere where we have clients. And so we're here to help with handbooks. That's a core part of what we do here at Bond. So don't hesitate to reach out. And if, Kate, I could ask you please to move to the next slide. I'm going to first make sure that all of you are aware of two things. First, if you go to the slide that follows, we have several remaining labor and employment law fall breakfast briefings. Most of them are behind us, and we thank all of you who took the time to attend them. There's one on Long Island actually today. There is another one in New York City on Thursday, as well one in Watertown on the 24th and one in Westchester on the 27th. It's not too late to sign up. Let us know if you have an interest, and we'll see whether we can squeeze you in. And then the next slide, please, is a reminder that we are in the midst of Cybersecurity Awareness Month. And you heard earlier from Amber about just how important it is to pay heed to all that is to strengthen, bolster your cybersecurity posture. We'll be bringing additional programming over the course of the month to make sure that all of you have the tools that you need. And don't hesitate for a moment. If you have a question, we're here to help. That is really what Bond is here to do for all of you. So I wanted to make sure, and thank you, Kate, for providing the contact information of all of today's speakers, Amber, Sandra, Carl, Kamisha, and Mallory. You can reach out to me, of course. I look forward to being back with you on Halloween. We'll see whether I'm wearing a costume. Before that, you'll hear from Kristen on the 24th, and there's a great program coming up a week from today. So please tune in. We appreciate your loyalty. Thank you so much for taking the time to be with us today, and have a great afternoon.